Hi, everyone. We're just admitting people from the waiting room, so we're going to wait a couple of minutes. All right. Well, I think we can get started now. Bonjour, everyone. Hello, my name is Angela Riley. I'm a professor of law and American Indian Studies at UCLA, and I'm the director of the Native Nations Law and Policy Center. I am coming to you from Los Angeles on the unceded land of the Gabrielino Tongva peoples. And we are so delighted to have this event here today. Before I launch into the conversation, I want to just make a couple of announcements. One is that this is the first in our speaker series, which will continue throughout the summer. We have all the dates TBD because we plan to do them along the lines of this one, which is that when something exciting happens, particularly when the Supreme Court decides the Indian law cases, although we had one just come out yesterday, we're going to try to organize these quickly to do exciting debriefs on the cases with the lawyers involved in the litigation. So that said, be on the lookout for more from Native Nations. I also wanted to just say a couple of words about our job searches. Here at UCLA School of Law, we are now looking for a new San Manuel Band of Mission Indians director of our Tribal Legal Development Clinic. Now that I'm delighted to say that Lauren Van Schilfgaard, who has been directing our clinic for the last few years, is now going to be joining the UCLA law faculty as a tenure track faculty member. So welcome, Lauren. Very excited about that, which means that we are now in a search for someone to fill her position as the director of the clinic. So we are putting the job search postings in the chat. If you are interested, please apply. Feel free to reach out to me or Lauren with questions, and or pass that link along to someone else if you know someone who might be interested. The other thing I'm very excited to report is that with generous funding from Agua Caliente, we have our first ever Indian Law Fellow here at Native Nations, as well as the School of Law, which we're also searching for. The ideal is someone who is interested in potentially going on the teaching market and becoming an academic in the field of Indigenous rights, sort of from tribal law to international. It can have a broad range. So we also are going to put that search in the chat. So if you are interested in that or know someone who is, please encourage them to apply. We're hoping to get all of the applications in the next month or so and be hiring for the fall semester. So with that, I want to just welcome our panelists and say a couple of words about the Denezpi case, which of course, as you all know, just came out a couple of days ago. I'm going to give a brief recitation on the case. I'm not going to say too much. I think most of you out there probably know a lot about the case already, and there's so much juicy stuff to dive into. As you probably know, the brief background is that Mr. Denezpi is a member of the Navajo Nation, and he was charged with 3 crimes that were alleged to have occurred on the Ute Mountain Ute Reservation. Those crimes included 1 charge under the Ute Mountain Ute Code, and then 2 additional charges under the CFR Code. That was filed in the CFR court. Ute Mountain still has a CFR court, along with a few other sort of tribes and regions in the US. I think there are 5 total, with several of those being in Oklahoma. So hello to all my Oklahoma people. He was charged with 3 different crimes, and ultimately he pled, well, he actually entered an Alford plea and ended up to the Ute Mountain Ute charge, and ended up being sentenced to time served and 140 days imprisonment. And then 6 months later, a federal district court issued an indictment on account of sexual abuse, aggravated sexual abuse, which was covered by the Major Crimes Act. And Denezpi moved to dismiss the indictment on double jeopardy grounds, essentially arguing that CFR courts are federal courts, and therefore he had been tried twice by the same sovereign. This, of course, is a twist on other double jeopardy cases we've seen coming out of Indian country that had slightly different facts, and didn't involve CFR courts. One thing I just want to start out, we had a little conversation before all of you joined, is that this case was decided on grounds that no one, I think, thought that it would be decided on. I myself have to say I was really, really surprised when reading the opinion. I just wrote a very long law review article on double jeopardy in Indian country crimes, which will be coming out later this year. And I have to say, this opinion has kind of upended my whole thinking about the analysis in that article. And so I'm just really excited to hear from the people we have here today who are experts in the field and who, of course, are the people who did so much of the heavy lifting on this incredible case and this historic win. So we're going to hear today from Jen Weddle, who is a longtime friend and colleague of mine, who is a shareholder at Greenberg Traurig and heads up their Indian law division. We're going to hear also from her colleague at Greenberg Traurig, Troy Ide, a longtime Indian law lawyer, advocate, and former prosecutor, and another good friend, Professor Greg Ablavsky, who is a professor at Stanford Law School, who teaches Indian law and a variety of other things in the area. I should also just add that Jen, along with Troy, authored the lead amicus brief in the case on behalf of Ute Mountain and the other CFR tribes. And Professor Ablavsky was one of the authors on the legal historian brief in the case as well, another amicus. So what I want to do is I want to start off actually by turning this over to Jen. We've had a lot of conversations about this case leading up to this week's opinion. And one thing that Jen expressed to me from the very beginning was that that the tribe, in essence, was going to prevail in this case. She had no doubt about that. She called this one really early on. So I want to turn it over to Jen to ask her why she was so confident about the case and what was it about the opinion that either surprised her or was exactly what she expected it would be. Jen, I'll turn it over to you.
So I would say surprised in a good way on the grounds for the ruling, but happy to see the result. And I personally was really confident in the result because I think it's exactly on trend with where the US Supreme Court has been going, especially in their Indian law criminal jurisprudence. As UCLA fans know, Troy and I were also counsel of record for the tribal government's amici in the United States v. Cooley case, which we prevailed on 9-0 in 2021. Really, I think that case showed us, again, a surprise where the court kind of ignored what they've been doing the last few decades beforehand, mushed it all together and came up with a very sound, practical result. And I think this is really more of the same as what they did in Cooley. In Cooley, you'll recall that was about whether a tribal police officer's traffic stop adduced evidence could be used in a federal drug prosecution. And the US Supreme Court ruled emphatically yes, ignoring the machinations about who paid that officer's salary and, putting aside the prosecutorial authority to say, this is really about how can tribes keep their communities safe. And that's been the overwhelming focus of amicus briefing before the court, not only in Cooley, but here in the Denezpi case as well, where we've had a strong cohort of academic historian writers, former US attorneys, including a very, very strong, I think 41 total, Troy, signers from Democratic and Republican administrations, including I think the most former US attorneys from the Trump administration, actually. And, shout out to Trent Shores for gathering a really tremendous group there. To advocacy groups, I know Mary Catherine Nagel is on the line and has done just tremendous work for the National Indigenous Women's Resource Center. And Troy's own professional work and scholarship and the work of the Indian Law and Order Commission has all really led up to where these briefs have gone and made a very strong record about how broken criminal justice is in Indian country, and coined the phrase indefensible morass, which Justice Kavanaugh actually read aloud in the Cooley oral argument. And then all the justices questioned again here, and we've seen the court really struggle when confronted, I think, with the blatant racism of their previous decision making, starting with Oliphant, finding that tribal court criminal prosecutorial jurisdiction over non-Indians would be inconsistent with our status as conquered peoples, and the parade of horribles that have flowed from that. And now the scenes of extreme injustice in Indian country, Ute Mountain is a terrible example of that. In the early 2000s had a murder rate 11 times that of the rest of Colorado. It was coined, the murder capital of Colorado, an incredibly violent rural place where people know they can go to get away with anything. And Mr. Denezpi was another example of that. He came up to the reservation from Navajo, committed a very violent sexual assault, and then was on the loose in the community, hiding in a neighbor's yard in a shed. Had injured his victim to the point that she could not stand or walk after the assault. And the only option to take him into custody, to apprehend him, to get him off the street, was to immediately book him for a violation of the tribe's law and order code, essentially a misdemeanor. But it got him off the street for 6 months, which was the time it was going to take the U.S. Attorney's Office here in Colorado to determine what to do next. And I want to pass to Troy on some of the more practicalities, but I guess I would also just say that Ute Mountain in general is, very large rural reservation, faces many of the same issues that other large land-based tribes in the West face, where there's a tiny handful of BIA police officers to patrol, an area the size of the state of Rhode Island, that spans Utah, New Mexico, and Colorado, very under-resourced, but they do the most with what they can. And I want to come back to this point later, which is with respect to its CFR court, even though it's under-resourced, even though it has this very troubled assimilationist history, Ute Mountain has done their best to make lemonade of the lemons of the CFR court. And I think the court recognized that here and fundamentally respected the tribe's sovereign decision to treat that CFR court as its own, to respect its decision to use that as its primary tool to enforce public safety, and to give the tribe at least a chance to do something to safeguard the community. So Troy, do you want to talk more about the Colorado U.S. Attorney's Office and that bigger picture of criminal justice in Indian country?
Let me just thank you for that, Jen, and thank everybody on the call. This is a situation where teamwork makes all the difference. And if you've ever seen a case where teamwork mattered, it was this one. We had the scholars brief, which really was able to flesh out the tortured history of these CFR courts, the courts of Indian offenses. We had the on the ground experience that many of us have and have worked on this over the years. I'm actually the chief judge pro tem of this tribal court. So on conflicts cases, I go down there and hear the docket. And we had a lot of on the ground expertise. The U.S. Attorney's brief that was mentioned, I go on and on, but everybody helps with this. And so just a couple things. One is just the power of having different perspectives. We really spent a lot of time trying to make sense out of, well, how do we treat this? From a tribal sovereignty standpoint, it would seem like not too many tribes are really affected by Denezpi. But when you think about it, there was a pretty big premise that came out of here, at least as a reference point, which was that while the court ultimately assumed that it didn't make a difference if it was federal law or tribal law, they did accept the idea that we were applying Ute Mountain Ute tribal law to the situation. And I mention this because the tribe has worked really hard for many decades to create its own body of law that is not a federal body of law. that's different and we think better for the community. And it mattered in this case. It actually, I think, makes a difference because ultimately the fact that that was the source, it was coming from the tribe, it was not just simply a federal code. And you have to ask yourself, well, after this ruling, if they had applied, a federal, one of the provisions in the CFR itself, for example, it looks like the outcome would have been different. So that all of that work, which took place over many years and was much discussed by the tribal council, made a big difference. And then when we were preparing for this brief, we talked a lot about that too, and the sources of the authority, including the prosecutorial authority, but also the body of law itself. And so the teamwork made this, it took a very difficult situation. It enabled us to then, the second point, make it simple for the court. Now, I'm going to just guess, I don't know, but I couldn't find any instance where a Supreme Court justice, current or past, had spent any time with the CFR courts. They've certainly not written about them. They don't really appear much in the, I mean, you have to dig around, right, to even learn about them. You could practice Indian law for decades and never run into one, unless you just happen to be in one of these few places that still has one. And when you think about it, how do you even explain it to them? How do I explain what it's like to you that we have this strange hybrid court where even my position as Chief Judge Pro Tem is a 638 position. I'm just kind of carved out, and yet I'm in the Ute Mountain Agency, with Ute Mountain Agency staff, and we're all working together to do these cases. It's very hard to explain to someone if you never even knew there was this court. And what we were able to do as a group is to make it simple. You got to give the court a reason to rule for you. You have at least a majority here that want to put the interests of the community first. Maybe they won't be able to get there, but they got there, I think, because they could read briefs that show that it would be extremely dangerous at a practical level if we got rid of the protections that the community has, which is to basically say that the misdemeanor code doesn't do a whole lot. You can't get people off the streets. You need to be able to find a way to hold people sometimes for a little while until the feds can get their act together, say, and then be able to do their job if somebody is really violent. And I can tell you that down there, you've got a very small group of people who reoffend and reoffend and reoffend, and alcohol is the cause, we think, 98% of the time, and drugs probably the other 2% of the time. It's a very tough situation where very few people are constantly offending and reoffending. And you need that practical tool, because if you're just relying on very limited terms of incarceration in these very extreme violence cases, you don't have a lot to work with if somebody can do an Alfred plea and then call it a day and just catch and release. And the court, I think, could see that. You can communicate with the justice and say, all right, it's very complicated, the history's tortured, but at the end of the day, do you want to make this community safe? They found a way to do it somehow without very much money, with a median household income of less than $7,000 a year. They found a way to keep this community safe. Are you going to really step in Washington, D.C. and screw that up? And maybe they can't get there, but in this case, they found a way to get there. And that's why I think you see this sort of agonized dissent from Justice Gorsuch, who has always been very protective of defendants' criminal rights and concerned about that issue. That he brings it out, and he makes some very good points in his dissent. But at the end of the day, you want to give the court a reason to rule for you. And I think we all, as a team, came up with a good reason, even though the history of the court itself is pretty hard to explain and pretty tortured.
Well, thank you, Troy. And I just want to jump in there for a second and really dig into the opinion, because and first of all, congratulate you all and all the people who worked on this case, on this historic win, because I agree with you that it does, in practical terms, have a lot of really positive impacts, I think, especially for the tribes still operating CFR courts. I had sort of envisioned another really easy way for the court to resolve this, which would be to say CFR courts are tribal courts, and therefore there was no double jeopardy, which is sort of how I thought it. That's sort of was my fingers crossed version. And the opinion that we got is nothing like that. It's really very, very different. And of course, Amy Coney Barrett writing for the majority of 6, which included Breyer. So it's just so many twists and turns. So one of the things I want to do is I want to turn this over to Greg and ask, one, what's your take on this 6-3 and how this split came out? And also just to dig a little deeper on one of the points that Troy raised, because it seems to me, I agree with Troy on the point that Denezpi had 3 charges against him and he pled to the tribal charge. If he had was that strategic? I don't know, probably not. But if for some reason he had pled to the federal charge instead, would this case have come out differently? So I'd like for you to dig into the actual opinion a little bit and give us your take on what you read on June 13th.
Great. Well, thanks again for the invitation. Lovely to be here with this distinguished group of scholars and litigators. I will say I was also pretty surprised because, like you, Angela, I thought, in fact, when Maggie and I wrote our brief, we teed it up precisely to make that argument, right? That the CFR court, despite the tortured history that Troy alluded to, was in fact a tribal court exercising tribal authority. And we thought that was a really important argument to make. And of course, that's the argument that the Ute Mountain tribe was itself advancing. And as you say, that's not the direction the court went. And so I will say that I think there's grounds for some concern in the future, despite this important win, for a couple reasons. So one concern that I have for the future is what Justice Gorsuch points out in his dissent, where he suggests not only that if Denezpi had pled to the federal charges, this would be an unambiguously federal offense, but he suggests even that the tribal code pleading was also a federal offense because it was adopted by the federal government as part of their regulations. Now, the majority doesn't really take this up and dismisses it in a footnote and says this isn't before us right now. In Wheeler, we didn't suggest that this was actually a federal offense. But nonetheless, the suggestion that tribal law could become federal law if it is enforced by the federal government, I find very concerning. And the Gorsuch actually sort of lays out a future challenge, both on that ground and on the ground that the CFR courts are not sort of fit within the standard Article 3 or even non-Article 3 model. He basically lays out a challenge under the new strictures of administrative law. And I think what's interesting about Gorsuch's dissent is he challenges very strenuously the idea that anyone could read the CFR courts as an expression of tribal sovereignty. He calls this as a sort of, deeply revisionist line. And he's ignoring, as was brought out by Justice Kagan at the oral argument itself, he's ignoring the fact that the tribe itself was arguing strenuously that this tribal court is an expression of its authority. So what worried me a little bit there was Gorsuch's willingness to sort of claim to be an advocate of tribal sovereignty, well, to me, ignoring what to my mind is the most core feature of being an advocate for tribal sovereignty, which is respecting what tribes themselves say, right? Like what it means to respect tribal sovereignty is to respect tribes and their own determinations and decisions about what is good for them. Now, I think that probably reflects the fact that Gorsuch has a particular view about double jeopardy that stems from his dissent in Gamble. So as Troy alluded to, right, he has a particular solicitude for criminal defendants. And so I'm hoping this is a one-off, but I will say there were strains in that dissent that gave me pause about the future, and the fact that the majority didn't really respond to them. So I'm thrilled at that given especially what happened at the oral argument, with so much focus on the prosecutorial authority. I'm thrilled that they didn't go in that direction, but I am still concerned about what this decision might portend for future situations where, this is not the only instance where there's a very complicated history. This is one of many instances where tribal and federal authority are really complicatedly entangled in federal Indian law. And I worry that the court, in its embrace of formalism, is going to have a hard time disentangling those. And if they just take the Gorsuch view that this is all federal all the way down, I could see us, having to litigate a lot of these cases down the line, and I worry that the court would look less favorably on them in the future.
So I might jump in there to piggyback off what Greg said, which is, I think he's absolutely right that we should be concerned because the court continues to just make it up in Indian law, and happily they're making it up in a pro-tribal sovereignty way in this instance, but it's really not tied to a discernible set of foundational principles yet, or to Indian canons yet, really. And I would say I strongly share Justice Gorsuch's discomfort all around when he notes that the CFR courts were created chiefly to attack religion, medicine men, mourning practices, dance, to go after the heart of tribal culture. And could something that comes from such an evil place ever be assimilated? Truly, probably not. But it's all that Ute Mountain has. I would also say, Justice Gorsuch is quite right to question, what is the authority of the executive branch to pronounce itself legislative, executive, and judicial over anyone, much less tribal nations with a government-to-government relationship and treaty relationships with the United States? That's absurd. And I think he does lay out that challenge case, and that's why every tribe that is still reliant on a CFR court should be reviewing its own code, making sure that as a matter of tribal law, these offenses are codified, because I think any CFR court prosecuting a federal offense, that's a no-brainer challenge at this point. And it truly this truly does tribalize more the CFR courts. And I just note that even at oral argument, counsel for Mr. Denezpi kind of volunteered that and said, well, wouldn't it just be so much better if the Department of the Interior direct funded these tribal courts? Yeah, sure, please. And I think that there are going to be numerous requests to the department and to Secretary Holland to try to conform to exactly that. But the caution from the majority is, let's at least not take away this tiny reed of community safety, and let's find a way to do it. And doing that in a very formalistic, bright line way to say, okay, the tribe has exercised sovereignty. It's created the offense. The offense is codified in the tribal law. It doesn't matter who prosecutes it. It's the source of the sovereign. We're not going to look at the complexity. We're not going to look at the history. We're not going to look at the funding mechanism. We're not going to find a way for the tribe to lose based on all of those things. Instead, we're just going to say, is there a tribal sovereign action? If so, we're done and we're good. And I think that bodes tremendously well for areas all across Indian law, including concerns about tribes' economic enterprises, environmental regulations, civil jurisdiction issues. I love that the court is going in that direction.
Thank you, Jen. I want to just pick up on something you said and turn this question to Troy. So one of my fears was that if this case had come out the other way, that the court might have said CFR courts were federal courts, maybe leaving some ambiguity about whether and to what extent federal funding led a tribal court or a court on an Indian reservation to be a federal court as opposed to a tribal court. And I was concerned about that slippage there. That's not the opinion that we got, of course. And Barrett writes, in her opinion, we need not sort out whether prosecutors in CFR courts exercise tribal or federal authority. She says it doesn't even really matter, although she writes the opinion as if it's federal in my view. So I guess building off your question, Jen, I want to turn to Troy and ask the question, if you're a tribe right now and you have a CFR court, and Troy, you're very close to this because you are at Ute Mountain. How should tribes read this, especially tribes with CFR courts? What steps should they take to protect the criminal justice systems that they have, which are, as Jen mentioned, under-resourced as they are, making lemonade out of lemons? How should they view this case, and what steps could they possibly take to protect the infrastructure that they have?
It's a great question. And I just say, and I'm not talking out of school, if we could have a tribal court at Ute Mountain, I'm pretty sure we'd have one. That is to say, even during the time Jen and I we've represented the tribe since 2011. Even during that time, we had one instance where we thought we had enough recurring revenue that we could maybe swing it. It just turned out that was not the case, and the tribe had other needs. And the tribal council is, within Indian country, it's one of the most desperately poor places in Indian country in the United States. And we don't have a tribal police department either. And I go on and on. I mean, so the reality is that there are some places in this country, and we sometimes forget that, where and I heard from other tribes, attorneys especially, oh, why are you guys even taking this case? Well, of course, we had no choice. But if you're going to saddle up, right? You're going to defend the tribe's sovereignty as best you can, and pull your friends in and try to persuade them to suspend disbelief sometimes. But the accusation, or the implied accusation, was, well, why don't you just 638 everything? And the answer is that this tribe has tried, and it's not economically feasible. We just don't have enough revenue to do such a thing. So what do? We were developing plans for losing the case, and the tribe was considering all those things, and it was going to depend on whether there was an issue with who appointed the court and the prosecutor and so on. I mean, you start to think about how it could have gone, right? And we thought, well, could it be different, for example, if BIA revised its regulations so that if a tribe had the final say on who served, that it would become tribal, even though it was still a CFR court? Or could we make changes even in 638 itself just for this purpose? We started to look at the regulations and think about some workarounds, but we were guessing, right? Because we didn't know how this was going to go. We didn't know what the basis was going to be. When I listened to the oral argument, I thought, well, maybe it's going to just be some changes we make as to who appoints the judge and how that process works, and to make it more tribal, maybe that will be sufficient. But as you pointed out, Professor Riley, that just was not, that's not where they went. They didn't go in that direction. In that sense, they made it a lot easier for us. But the on the ground reality for everyone in this call is that it's hard. This is not a good situation. And for the other tribes, obviously I can't in any way speak to the other tribes with CFR courts, but I would say, as a former United States attorney, it's just a very difficult situation to be in, where a tribe wants to be able to create a tribal police department, a tribal court system, and does not have recurring sufficient revenues to do that. It's a sad statement about the United States, the trust responsibility. I of course, would have loved to see some language in the opinion about that.
Yeah, thank you so much for that, Troy. And growing up in Oklahoma, and there are CFR courts still in Oklahoma, and I think maybe 3 of them are there of the 5. So I've sort of grown up with that language around me, and I think it's similar issues there for transitioning to a full tribal court. I want to kind of pivot for a second and kick this over to Greg, because as I mentioned at the beginning, having written this long article on double jeopardy and relied heavily on Sanchez-Valle and Gamble, I'm now reading this opinion and sort of thinking, maybe I completely misunderstood double jeopardy all along. This intense emphasis on offense, to me, is drawing lines that I've not seen drawn before in the precedent. And what it really made me think is, well, one, how are prosecutors in Indian country going to view this? Like, how does this impact charging and prosecution in Indian country? But even bigger than that, it's really made me think this opens the door to a lot of state, federal, I don't know, I don't want to say bad behavior, but for the opportunity for prosecutors in the state and federal system to similarly look at this opinion and say, hey, there are ways to get around double jeopardy problems here and getting 2 bites at an apple. So I'm really curious, Greg, on your take on this opinion in and outside of Indian country in the double jeopardy realm.
Yeah, I mean, I think you're right to see this at odds with what Sanchez-Valle and Gamble said. I mean, this goes back to what Jen was saying a moment ago, which is that they're making it up, and they're making it up not only in the context of federal Indian law, but they're also making it up in the context of double jeopardy, right? I mean, I think everyone read this case, or everyone who was planning for this case was sort of framing it in terms of what they said in Sanchez-Valle, right? We need to look at the historical well springs of authority, and what are the sources of the authority, and where exactly does the sovereignty come from? And then lo and behold, right, they sort of spring on us this new test that I don't think anyone quite anticipated. So, I can tell you, I've talked to a couple sort of criminal law oriented folks who have precisely that concern that you just articulated, Angela, that the real significance of this case is actually going to be less for what it means for federal Indian law and more for what it means in the state federal context, where now you have the prospect that federal courts could prosecute, federal prosecutors could bring state and federal charges, maybe seriatim, right, one after another, or vice versa. I suppose in the Indian law context, there could be a world in which now federal prosecutors could bring maybe even tribal alongside federal charges. I mean, I defer to Troy to know if such a thing would even be possible. But it certainly creates, and the court says there might be other provisions of the Constitution that forestall this, but not double jeopardy. Sort of throws that line in at the end, raising maybe some sort of due process concern. But yeah, I think it opens up a great deal of space for creativity in criminal charging. The other thing I will say is just something about methodology, right? I mean, and this is, we saw Isleta yesterday too. What I'd say both of these is demonstrate just how much textualism this court has really embraced, right? That both with respect to the double jeopardy clause and then with the respect to what the litigation in Isleta, these are heavily textualist opinions. It reinforces the fact that textualism is the dominant methodology at the court, even when it reaches some odd results, right? I mean, I was speaking to someone, one of my colleagues who litigates some of these sorts of cases, and he was saying, you know, if you keep reading, the double jeopardy clause says, you know, life or limb. So does that mean that the double jeopardy clause can only apply in death penalty cases, or, you know, if there's some sort of corporeal punishment involved? I'm sure the court would reject that as an absurd result, but it does, I think, underscore just how much textualism there is at work here. I mean, I think that's something to be mindful of as we await Castro Huerta, and then also as we think about the giant behemoth that's waiting for us in Burkina next term.
Yeah, thank you for that. And I want to do a little bit of that looking down the road before we close. We have a little bit more time. But before we turn to that, I wanted to just ask, I mean, as people on the call know, Gorsuch wrote the majority opinion in the McGirt case, which of course has had a ripple effect all across, certainly Oklahoma, but even across Indian country. And of course, now we're going to hear Castro Huerta or get a decision there later. So with that in mind, I'm curious, Greg talked a little bit about Gorsuch already, but I'm curious from Jen and Troy, what was your read of the dissent? And did you find it surprising, not surprising? I had kind of in my own imaginary life imagined the dissent being the majority, but with a finding that CFR courts were tribal, if that makes sense. But as I read Gorsuch's opinion, so much of it seemed intuitive, whereas the majority opinion did not seem intuitive to me. It felt wrangled and forced. And I was kind of perplexed. So I'm really interested to hear what you all think about Gorsuch's dissent and how you think that might give any insight into his ongoing views in Indian law cases.
So my take is that, you know, having been U.S. Attorney in Colorado when Judge Gorsuch was on the 10th, there was no more pro-criminal defendant judge in the 10th Circuit than Neil Gorsuch. McGirt has been misunderstood on one level, in my opinion. McGirt was perfect for Justice Gorsuch because you had a criminal defendants' rights case. And primarily, I would respectfully argue, it's not surprising that he was the one who wrote that case. And then he also was able to, of course, get into tribal sovereignty. But what you see in this case is where I think he typically will come out. If you have Indians butting up against criminal defendants' rights, you're going to see the criminal defendants take precedence. And that's my observation from watching him for many years. And like I said, there are valid reasons for that, and that he sees, and I'm not questioning it. But I think it's just one of those instances where these set of interests shook out differently. And I think he was concerned, honestly, about the rights of Denezpi. I will tell you, though, that please read the U.S. Attorney's brief if you haven't. Trent Shores is absolutely brilliant. He says, well, of course, no U.S. attorneys ever appeared in a CFR court. A lot of the U.S. attorneys didn't even know what in other states without them, didn't even know what a CFR court was. They had to look it up. We had to explain what they were, and we had to show them where in the regs these things are. There's no record of any U.S. attorney ever appearing in any CFR court. And the idea that you coordinate with a CFR court as a former U.S. attorney in Colorado is absurd. It just never happens. And that's what he points out. And I think that had a huge impact. I just thought that brief was of the former U.S. attorneys written by Trent Shores was absolutely brilliant and spot on to just show look, there's no coordination going on here. Now you might say to yourself, and I'm getting to Greg's point a moment ago, Greg had this parade of horribles, and he's paid to do that, which I really do respect. But at the end of the day, the U.S. attorney is someone who, by law in the statute, you enforce the U.S. criminal code and you represent the United States when it's a party in a civil action. That's the statutory definition. There's no authority to enforce anybody else's law. You can't enforce state law. You can't enforce tribal law. So as federal courts are courts of limited jurisdiction, federal prosecutors also have a very narrow, statutorily defined jurisdiction, as U.S. attorneys do. So I don't see any particular broader risk here to criminal defendants. And I certainly think that the Justice Gorsuch dissent is well worth reading. But at the end of the day, I will disagree with you. I thought the majority was breezy, like Neil was breezy in McGirt. Oh, well, all of Oklahoma is going to change now. That's your problem. Go figure it out. Oh, this is just the Major Crimes Act. Does it apply to civil? I don't know. No offense. I mean, he left those issues out, and that's great. I thought that was appropriate, but it was kind of breezy, wasn't it? I think the majority was breezy too. Well, we don't have to get to that. We don't even think Denezpi asked the right question. And then they just laid it out. So I thought it was great.
Great, thank you. Jen, do you want to take that up?
My response to anything Justice Gorsuch writes is just hearts emoji, like lots of them. Like I said before, I really appreciated his attention to the religious attack foundation of the CFR courts. And I think that's really indicative of how informed a Justice Gorsuch really is. He's our lone justice from the West. He took the time as a 10th Circuit judge to know and understand tribes, to travel to the reservations, to attend every rubber chicken dinner with me and John Echohawk and all the other NARFers that are on this webinar. And he really knows and respects these issues. And I think that's just highlights how important it is for tribes and tribal organizations to have a voice in judicial nominations and confirmations, not only at the U.S. Supreme Court level, but beyond, and to really fight for that representation on the court so that it's not just, an ivory tower of East Coasters who've never met an Indian or been west of the Mississippi.
Yeah, thank you for that. Well, I want to pivot just a little bit in the time that we have left, and I want to look 24 hours back and 24 days forward and maybe 24 months forward. So as many of you know, the decision came down yesterday in Isleta del Sur Pueblo versus Texas. I haven't even had time to read the opinion yet. The short of it, of course, is that the tribe prevailed in a dispute with the state of Texas over bingo gaming on the reservation and a question of whether their Restoration Act or the Indian Gaming Regulatory Act controlled, using a lot of the language of cabazon and the regulatory versus prohibitory distinction. And I'll give a shout out here now to Carol Goldberg, who I don't think is on the call, but who did a lot of that work leading up to cabazon. So with that as the case, we just, now we have 2 of the 3 that are coming down. We're still waiting on Castro Huerta. I guess with Castro Huerta really hanging out there as the really, really big one. I'm curious, I'm going to start with Greg, but ask, given what we've seen so far and what happened yesterday, where do you think we're going to end up with Castro Huerta? And if you want to even talk a little bit more about how does that then lead into Brackeen?
So I feel like I'm terrible at the prognostication, but I'll do my best. I think the surprising vote in Isleta was Barrett, right? I mean, I think it's basically a rematch, or it's the McGirt alignment all over again, but with Barrett taking the place of Justice Ginsburg, which is a little unexpected. Now, I think there are a number of possible explanations for that. When you read the opinion, the dissent says something akin to, well, yes, we know the plain text of the statute says X, but we're going to look to the legislative history to explain it. Which, for those of you who follow closely, as Troy pointed out, I'm paid to do. For those of you who follow closely the ins and outs of the Supreme Court's methodology, looking to legislative history is a serious no-no if you are a sort of conservative textualist. And so I think it was, I mean, it's similar to the move that the dissenters made in McGirt itself, where they sort of said, well, we know the text says this, but we're going to look to the broader history. So I think part of this might reflect Barrett's broader disposition in terms of methodology. So what does this mean for Castro Huerta? I think we can safely assume that, I guess, again, after the oral argument, I'm optimistic that Gorsuch and the 3 liberal justices are on the side of the federal government in that case. But I worry about what Barrett will do in a case where there's a lot less text and a lot more fights about structure. And that, I think, means that she could go either way. And I think, unfortunately, she might end up being the swing vote there. My hope is that the Supreme Court doesn't want to create more of a morass than it already has in this area, and would recognize that overlaying state jurisdiction would make things much worse and not simpler. But this is a court that is very solicitous for state sovereignty. And then looking forward to Burkine, the hard thing about Burkine is there's about 20 different issues floating around in Burkine. And some of them are pitched to some justices more than others, and some of it fits very squarely within a sort of movement conservative commerce means only trade. Some of it is pitched toward a sort of way of thinking about quote unquote racial preferences and affirmative action, which of course we know is not the right way to frame ICWA, but nonetheless is the way that it's been teed up for justices like Alito and maybe even Roberts. So, I think there's just a lot of cross-cutting things going on in Burkine that make it very hard to know what's going on here. I will say, I think Isleta was heartening because, and hopefully Castro Huerta, because I think Gorsuch has shown that he's not super sympathetic to state sovereignty arguments in Indian law. And I think that's going to be really important when it comes time for both of those cases.
Great, thank you. Jen, you want to jump in?
Sure. I would be, I think, more optimistic than Greg on the outcome of Castro Huerta, and I think we'll go 3 for 3 this term. And I say that because I think we see the court steering toward a very formal notion of textualism, and we saw that in Denezpi with the focus on, okay, what is the source of law? What is the tribe's legislative action here? And we saw it in Isleta yesterday by them focusing on, well, what did Congress specifically say? They're looking to what did the Fed say? What did the tribes say? And as Greg points out, when it's more about structure and not about the words that either Congress or a tribe has spoken, where does she come out? And I think her opinion in Denezpi shows her extraordinary penchant for restraint, brevity, simplicity, and the idea that one shouldn't be just making it up as you go along. And I think she got a lot of that from her mentor, Justice Scalia. And I don't think we're going to see her racing to create a way where states must win. I think that she very fairly and impartially applies her notions of restraint, and I would look for her to be in a majority for the tribal sovereignty side of that case. And again, I think that's also positive on any treaty rights-based issue where, if your starting place is the treaty, the question will be, where did Congress ever cut back on the treaty or inhibit the treaty rights in any way? And I don't think there's any basis to find that in Castro Huerta.
Thank you. Troy, I'm going to turn it to you, but I'm going to also ask you a question, which is, what would the implications for criminal jurisdiction be, even outside of Indian country, if the Supreme Court decides Castro Huerta against the tribe's position? In other words, saying that we are going to add states to the mix. What's that going to do?
Well, it would be one of the biggest unfunded mandates of all time in terms of a federal mandate. When you think about it, there would be political pressure on all these states, including my own state, to start to expend all sorts of money that we don't have on this issue, because these are citizens of our state as well as of their tribes. But I don't think that's what's going to happen. I've wondered, why did they take the case to begin with, and why did they just raise this one question? Well, you know, we've had a lot of bad behavior by Oklahoma, no offense, but and I'm not saying it's as bad as After Brown versus Board and the 10 years of, you know, various southern states refusing to implement the Supreme Court's decision. But in our lifetime or in modern times, when have we had a state just simply refuse to acknowledge what happened in 2020 with this case? And, you know, and I mean, on the ground, having spent time out there, I'm amazed at, even at the intergovernmental level, where the state could be doing so much to work with tribes that are building their capacity and are working with the feds, there's been so little accomplished by the state. But they have spent a lot of time running to the Supreme Court. What is it, 40 some times now they've been up there. And they have spent a lot of time on TV and YouTube and everywhere else complaining about the, you know, the end of days. And so the bottom line is, I think, why did the court take this? They took it because Oklahoma's been acting in a disrespectful way. They can't seem to get over their grieving process, a few state officials, that is. And now the courts just found a way, once they slap this down, because actually this is one of the few questions in Indian law, right? That's kind of a basic question. Congress never did directly necessarily speak to it. We just all assumed one thing. I don't know. There's enough ambiguity that okay, the court can address that issue, and they are going to address it. But once they tell us what we already know and what Congress has assumed for, you know, well over a century and a half, that states don't have this jurisdiction, then I think it's going to really undercut Oklahoma's continued defiance of the Supreme Court. It's a way to basically say, we did McGirt, we meant it. You can run up here, you can spend $4.4 million on your law firm and have as many press conferences as you want. But at the end of the day, we're the Supreme Court, and you're going to need to implement our decision, and you should be doing a better job on the ground. And why do I say that? Because the whole majority, right, the 5-4 majority, Justice Gorsuch's position was, if there's an issue, let Congress address it. It was a separation of powers case in that sense. And after the court decides this question in Castro Huerta, there's nothing really left to do except to say, all right, Oklahoma, if you really want to do something here and you're that concerned, go to Congress and get something accomplished at that level. But you're going to need to get the tribes involved for any legislation on a practical level. So that's why I think they took the case. That's why I think we're going to have a good result for the tribes. And hopefully it will change this sort of World War I static warfare in Oklahoma that the state of Oklahoma continues to propagate on Native people in Oklahoma.
Yeah, as an Oklahoman, I'm about to go back. It's really interesting to be like living the Kagama language of the states or the tribe's deadliest enemies. It's like why our state has to be at war with the tribes in Oklahoma, I do not understand, but it's a long history. We have a question in the chat, and I'm going to read the second part of it. The question is, was it implicitly assumed that the tribal assault and battery crime was the same crime in terms of its elements as aggravated sexual abuse in Indian country?
I think the issue is who gets to decide. This is my view, and then Greg can correct me. Seriously, correct me, Greg, but I think it just matters who writes the offense. I don't think it makes a dime bit of difference if it had been identical wording, identical requirements. It's the source.
Yeah, I think that's right. I mean, I think if they had been completely different offenses, then we wouldn't have even gotten necessarily to the double jeopardy question at all. But I think it's one of many things that, as you said, Troy, in this breezy opinion, they sort of bracketed and set aside. So I actually think you're right about that. I will suggest maybe I'm less optimistic about Castro Huerta than you are, Troy, though, because if there's one thing that Denezpi reiterated, it's that when justices dissent, they don't give that up. They harbor that grudge a little bit going forward, right? I mean, we saw that with Gorsuch, and I think we're seeing that. I worry that we'll see that with the change in composition of the court in Castro Huerta. I worry that the 4 dissenters from McGirt will see this as an opportunity to roll back some of the majority decision. So, you know, again, I would love to be proven wrong. Maybe some of my pessimism is just a little bit of a self-protection here when it doesn't come true, and also maybe years of teaching federal Indian law and watching how the court sort of just takes radical turns without much basis in the prior doctrine.
So this is where I'll be the bright ray of sunshine after Greg's doom and gloom, and just say I think he maybe overestimates the justice's tolerance for pain. This is a court term when they've been rocked by the leak of the opinion and departing from longstanding court precedents, and there's hyper scrutiny on the court, and their allegiance to precedent or not. And I think particularly Chief Justice Roberts is concerned about that issue, and would try to find a way to not have a less than 2-year-old opinion undone merely by the political composition of the court having changed by virtue of the presidents who nominated the justices. I think it's too fresh, and it just invites further failures of confidence in the court. And I think they'll find a way to do what's right for the institution too. That goes hand in glove with the deference that they need to show to Congress. Congress could react in any number of ways, and certainly Oklahoma has been pounding the pavement in the halls of Congress, pandemic or no pandemic, they're out lobbying constantly. If Congress wanted to react to McGirt, they could have done it. If the executive branch wanted to react to McGirt with more resources, more federal resources, they could do it. To exactly Justice Gorsuch's point in the majority opinion in McGirt, that's not the court's lane. And I think that's why they'll resist doing a lot of damage to McGirt and Castro Huerta.
All right, I have one question that anybody can answer, and then I want your final words because I know we have to wrap up in like 2 minutes. So here's my question. If she had been on the court, would Barrett have been in the majority in McGirt? Answer that, and then you can give your final thoughts on anything.
As long as she came after Neal, she would be in the majority. I don't know if she were appointed before Justice Gorsuch, I'm not sure. But you will see her emerge as an ally.
Greg, Jen?
I agree completely with Troy.
I guess this is my role. I think she would have been with the dissenters and we would have had flipped 5-4. I mean, I just think that you needed an awareness and a commitment to the issues that Gorsuch has shown. Maybe Barrett has that, but I think it's much more likely she would have been swayed by the arguments that the rest of the movement conservatives were. So I think it would have been outcome determinative in the other direction.
All right, I want to give a virtual round of applause from all of us out in Indian country to thank all of you for your incredible work across the board, and the many, many other players who I know were involved in this case. But, against all odds, you did remarkable work. We all heard, some of the buzz out there and naysayers, but you pulled through yet again. And I'm just so impressed with all of you. Jen, Troy, Greg, thank you so much for being here and for sharing your thoughts with us on this case. We will be back as these opinions come out. We're going to be doing more of these. And thank you to our audience for joining us today. So Chimagwech, everyone, and go safely, and we will see you soon. Thank you.